Hello, my name is Russell Carlino. I'm the administrator for Allegheny County Juvenile Probation, and what we have prepared for you is a brief video that will answer questions to some of the most frequently asked questions that people have when they come to juvenile court for a hearing. This can be an overwhelming process for both juveniles and parents and guardians, but we think that these questions and the answers provided will give you some direction and some reassurance while you're here.
I'm on probation. What does it mean to be on probation?
So what does it mean to be on probation? It first means that a judge has adjudicated you delinquent of an offense, and that offense has to be a misdemeanor or felony offense. And the judge, after hearing all the evidence in the case, makes a decision. And if the judge determines beyond a reasonable doubt that you have in fact committed the offense and that you're in need of treatment, rehabilitation, and supervision, then the judge will adjudicate you delinquent. After the judge adjudicates you delinquent, there are a range of dispositional alternatives available to the judge. They range from probation to residential placement, and the most common dispositional alternative is probation. So it's likely that you'll return home on probation. Once you're home on probation, you return to the community under the supervision of your parent, but you will also be assigned to a probation officer. And this PO will visit you and establish guidelines and rules and regulations for you while you're active with the court. The first thing the probation officer will do is conduct an assessment determining your risk to reoffend and identifying any needs that you might have that will need to be addressed while you're active with the court. The results of the assessment will be shared with you and your parent, and they'll be included in what we call a case plan. The case plan includes all of the regulations, all of the rules and requirements for you while you're under supervision. We have three major goals for every youth under supervision. First, we want to make sure that we protect the community. So in your case plan, you'll have requirements like reporting to the probation officer on a regular basis, having a curfew, not leaving the county without the permission of a probation officer, perhaps submitting to random drug testing. Those are examples of requirements in your case plan that are related to protecting the community. In addition to that, we're very focused on accountability. And what that means is that when you commit a crime, you've actually harmed a victim and also harmed the community. And so as a result of that, you have to restore both the victim and the community. So it's very common for the judge to order restitution, and that would be money that is owed to the victim as a result of the crime you've committed, and it's the probation officer's job to make sure you pay that restitution to the victim. In addition, it's likely that you'll have community service hours, and this is how you repay the community, and the probation officer will oversee your community service work. On the competency development side, that's the third goal. So we have community protection, accountability, and the third goal is competency development. And what our goal here is to make sure that we move you ahead toward productive citizenship. Not only do you have to be a law-abiding citizen, we want you to be a productive citizen as well. So the PO will have in the case plan things that relate to your competency development, such as attending school and doing well in school, or obtaining a GED. And if you have your diploma or GED, then we'll be looking at some kind of employment or trade school or further education for you. In addition to that, we want to make sure that you have pro-social thinking. So we may assign you to a curriculum that will teach you to make better decisions. If after a certain period of time, and it's an indefinite period that you'll be on probation, minimally it's going to be 6 months. If you do well, you do everything that's outlined in your case plan, and obviously do not commit another offense, there's a chance that your case will be closed at any point after the 6-month juncture. Only a judge can close your case. Only a judge can adjudicate you, place you on probation, and only a judge can close your case. But the probation officer will recommend that your case be closed when he or she is satisfied that you've completed all the requirements in the case plan.
So I keep hearing my friends talking about an adjudication or a consent decree, but I don't know the difference between the two. So can someone explain it?
Being placed on a consent decree and being placed on probation are actually very similar. With either one, the juvenile is expected to do a number of things: perform community service, stay out of trouble, comply with any therapy or counseling for drug and alcohol that the court orders, and stay away from a victim. The The juvenile is also expected to pay restitution for any damages they may have caused. The biggest difference between the two is that with a consent decree, after 12 months, the charges will be automatically expunged, which means your record is clean. However, on probation, you have an adjudication of delinquency that is a juvenile court record. You can still get it expunged, but there's more steps to go through.
What does it mean to get a child's case expunged? How do I get my child's case expunged?
Expungement means that a juvenile's record, including all fingerprints, photographs, police reports, court records, documents, probation reports, are destroyed or erased. It is important for a juvenile to seek an expungement in an appropriate case, because that means that the juvenile's record will not appear anywhere, and it is of distinct advantage when the juvenile seeks employment, wants to go to college, into the military, and so forth. Some expungements are automatic. For example, if a juvenile petition is dismissed or the petition is withdrawn by the district attorney, then the court is ordered and required to expunge that record of that offense. If a juvenile is placed on a consent decree and successfully completes that consent decree and the case is closed, after 6 months have elapsed, the juvenile's record for that offense can be erased. Other ways to seek an expungement are for the juvenile to file a petition or a motion and request the court to expunge or erase their record. This can happen if the juvenile is 18 years of age or older and 5 years have elapsed since the last adjudication of delinquency and the juvenile has not been subsequently adjudicated delinquent or has not been convicted of a crime as an adult. If 5 years have not elapsed, the juvenile still may ask the court to expunge their record, but the district attorney must consent to the expungement before it can happen.
Oh man, I've just been placed on school-based probation.
What is school-based probation? Since I'm on probation at school, will other students know that I'm on probation?
What is school-based probation? School-based probation is when a probation officer is assigned to a school to deal with behavior and attendance. As far as confidentiality goes in a school setting, probation officers maintain a strict sense of confidentiality when it comes to students. We do have to do school notifications to notify school administration when there is adjudication, but it's not something that we would let all the rest of the students in the school know.
The judge told me I had to do all these things while on probation. Who's going to help me do them?
Well, thank you, Whitney. That was a very good question. Probation officers will try to provide young people with both specific and general opportunities and services. For example, the probation officer will receive a court order from the judge from which they will issue the conditions of supervision. And within those conditions of supervision, the probation officer will help you set up community service using an organization by the name of Abraxas Workbridge, help you with the collection of fees and restitution, and also engage you in specific services such as individual counseling, family counseling, aggression replacement training, and the victim awareness curriculum. Along more general lines, the probation officer wants to work with you to discuss your issues in order to have you earn a case closing someday. And in the meantime, we will keep providing your judge with updated progress reports so that you can leave the juvenile justice system better off than when you entered. And thanks again.
I was a victim of a crime, and the judge ordered a no-contact order. What does that mean?
A no-contact order is an order given by the court to ensure the safety of victims and witnesses of juvenile crime. This no-contact order means that the victim or the witness may not be contacted by the juvenile via email, text, writing a letter through another party. So the judge may say direct or indirect, and indirect being by family members or others that will be representing the juvenile. And this is to ensure that the victim or the witness feels very safe when going about their regular activities after the crime has been committed.
How do I apologize if I have a no contact order?
This is a great question because it is very important for you to take no contact order seriously. It also can be very important for you to apologize when you're ready to do so. Allegheny County Juvenile Court has two options for this, which your probation officer can help you with. One option is you can write down your apology, share it with your probation officer. Your probation officer actually can help you think about how to say it so it'll be most meaningful for the victim. If your apology is sincere and appropriate, and if the victim is open to receiving it, the Center for Victim can deliver it for you. The other option is actually meeting with the victim face to face. You cannot do this on your own, but you can ask your probation officer to arrange a victim offender dialogue through Center for Victims. In this meeting, you can discuss what happened, what you learned from it, and you can also hear victims' concerns and answer their questions. This is a great way to make things right and move forward and put this experience behind you.
How should I act towards my victim?
No inappropriate contact between the juvenile offender and their victim or witness means that there will be no behavior that will make the victim or the witness feel unsafe by the juvenile. This can be teasing, taunting, name-calling. It may even be a negative look. If the victim feels intimidated, this is what is meant by inappropriate behavior by the judge.
What happens if I run into my victim?
If you have no contact order, it is your responsibility to avoid communicating with your victim. If you attend same school, you run into them in the hallway or classroom, don't stare at them, make no gestures, don't talk to them, simply stay away. If you do not have no contact order and you run into your victim, it's best to stand back and follow their lead. If your victim approaches you in a friendly manner, you may respond in the same way. If your victim turns away and walks away, it's a polite thing to do to stay out of their way. If they seem angry or agitated with you, it is your responsibility to avoid interacting with them because additional charges may be filed against you. If you have any questions about this, you may contact your probation officer and discuss it.
I've been an adjudicated delinquent. Now what?
An adjudication of delinquency is not a conviction, but it's often treated like one. A juvenile may be denied many opportunities, and there are many collateral consequences that result from an adjudication of delinquency. For example, a child's eligibility to obtain certain employment or certain licenses to get employment may be hindered by an adjudication of delinquency. Some juvenile court records are open to the public, and many juvenile court proceedings are open to the public. If a juvenile was 14 years of age and older and charged with any felony, those records and the court proceedings are open to the public. Some adjudications of delinquency may affect a person's eligibility for public housing, and it might even affect the family if they live in public housing after the juvenile is adjudicated delinquent. If a juvenile has an open juvenile case, he or she may not be able to get into the military at that time, and certain adjudications may prevent them from ever entering the military service. Children who have been adjudicated delinquent of certain serious offenses will be prohibited from carrying a firearm. A child's driving privileges may be suspended if they're convicted or adjudicated of certain offenses. Access to schools and colleges, student loans, and so forth may be affected by adjudications of delinquency. Of course, if you're adjudicated delinquent, you may be required to pay fines, costs, court fees, and restitution to victims. And if that restitution is not paid by the time the case is closed or at the age of 21, then the juvenile will still be responsible later in life for paying those court fees and restitution. Juveniles who are adjudicated delinquent of certain sex offenses will be required to register, and their name will be on a sex offender registration list. Juveniles that are adjudicated delinquent of felony offenses must submit DNA samples and fingerprints upon the adjudication of delinquency. Juvenile records can be expunged after a period of time, but some records may not be eligible for expungement. For example, certain sex offense adjudications will never be eligible for expungement. A person who turns 18 is able to vote, and an adjudication of delinquency does not prohibit that. A person who is adjudicated delinquent can serve on jury service, but an adjudication of delinquency may affect one's immigration status. And if a juvenile has an adjudication of delinquency and the record has not been expunged, they have a record which may be considered by a judge in criminal court if that juvenile is convicted of an offense in criminal court.
Why do I need to be photographed, fingerprinted, and have my DNA sampled?
Whenever a youth is adjudicated delinquent of a misdemeanor or felony in juvenile court, they're required legally to give fingerprints. At the time of arrest, police can also take fingerprints and photographs, but if this has not been done, at the time of adjudication, fingerprints and photographs have to be taken. We utilize a live scan machine here at the juvenile court, and it's located on the 4th floor. If those charges are dismissed in court, at that time, we destroy those fingerprints and photographs. DNA samples are also required to be given when a youth is adjudicated delinquent of any felony offense. Also, there are 2 misdemeanor sex-related crimes where a youth can give DNA. DNA is a one-time, lifetime sample. It only needs to be given one time.
Can my child be placed on Megan's list?
It's no longer referred to as Megan's list. It's now referred to as SORNA. SORNA actually stands for Sexual Offender Registry Notification Act. If you are adjudicated delinquent for rape, involuntary deviant sexual intercourse, or aggravated indecent assault, you could be put under SORNA. Also, if you are adjudicated for attempting, soliciting, or conspiracy of any of these acts, you would also be placed on SORNA. Soliciting is asking someone to help you with one of these crimes or encouraging them to do one of these crimes themselves. Conspiracy would be when you and one or more of your friends agree to commit one of these crimes and one of you take action towards committing one of these crimes. Conspiracy has occurred.
For how long?
It depends on which offense your child was adjudicated on. Each offense falls into a different category. There's 10 years, 15 years, and life. If your child falls under the lifetime registration after 25 years, they can petition to have the registration dropped.
Who gets to see the list?
States are obligated to make certain information public, which may be found on a public website.
My son just got committed to the CISP. Now what?
The CISP is a Community Intensive Supervision Program, first established in 1990. The CISP was an alternative to young men being removed from their communities and placed in residential type settings. The CISP operates 7 days a week from 9 a.m. in the morning to 11:30 at night, Monday through Friday. Saturday and Sunday we run 2 to 10 p.m. The CISP has alternate hours depending on community service projects, activities, and outside employment opportunities for young men. All young men committed to the CISP are placed on electronic monitoring 24 hours, 7 days a week, and we have a separate department that monitors their movement. There can be no movement unless it is permitted by the probation officer. There is a probation officer in each CISP center. Each young man is required to attend school daily. They attend the program Monday through Friday from the hours of 4 to 9, and on Saturdays and Sundays from the hours of 3 to about 8:30, 9 o'clock each evening. There are phone checks each evening for each of the young men that attends the program. There are face-to-face that staff go out each evening and meet with the young man, verify that not only are they in their residence, but also to meet with the parent briefly for a signature page.
My child's on drugs, and I don't know where to go for help.
If you think that your teenager might be on drugs, there's a good chance that your teenager is on drugs. Parent instincts are really important. If you have a feeling that something's wrong, you need to do further investigation. For example, 1 out of 5 teenagers have done prescription drugs that were not prescribed for them. Teenagers, whenever they're asked, tell interviewers that they find a lot of drugs in parent medicine cabinets. So the first thing to do is check your own house. See if you have alcohol or prescription drugs that your teenager might be getting into. The second thing is your teenager involved with a new group of friends? This is a big sign that your teenager could be going through some changes that might involve using drugs. Also, is your teenager losing weight? Are they gaining weight? Is their hygiene much worse than it used to be? Also, you know, when teenagers do drugs, you'll see a mood change out of your teenager. Sometimes they'll get a lot more talkative, and if your teenager is usually withdrawn and suddenly he starts being real chatty, that could be a sign that your teenager is in fact on drugs right then. Otherwise, teenagers might do the opposite. They might come in and their eyes might look glazed over or like slits if they're doing marijuana, and they might head straight for their room. Sometimes they detour to the refrigerator first. The thing is, doing drugs is really dangerous. Don't pass it off like it's just a stage that they're going through. Really, drugs kill teenagers, and it's very difficult for a parent to know how harmfully your child is involved. So if you think your child is involved in drugs, or you've found drugs, you've been searching places like the inside band of their cap or the waistband of their pants, or maybe there's an old iPod that you thought looked weird and you found that it was hollowed out and there were drugs inside, get an evaluation from a professional. Also, look for support. There are parent groups out there where you can find information and support from other parents who have already gone through these struggles of having teenagers with drug problems. Just remember that it's a very dangerous thing. Don't take it lightly, and make sure that you do something. Allegheny County offers 2 resources for parents. Act 53 is a legal action that a parent can take when their child is not accepting clinical recommendations for drug treatment. A judge can order your teenager to participate in drug treatment. Also, Allegheny County Probation sponsors Parent Survival Skills Training, an educational support group. You can read more about Parent Survival Skills Training at gopsst.org. This is an opportunity for parents to come together and just get honest and level with other parents about how afraid they are, what the signs are that their child might be involved with drugs. And it's a good place to strategize some actions that parents can take.
So what does it mean for my child to go to placement? And why would my child be placed outside of my home?
A youth may go into placement after presenting delinquent behaviors that the court believes is contributing to further delinquency and is putting the community at significant risk. Upon a determination that the community cannot be protected while the child remains in the home, the court will direct that a youth be placed in an approved state license private program or a state license program. At the dispositional hearing, the judge will take considerations of all factors, inclusive of a risk and needs assessment conducted by the PO that will help identify the appropriate level of care and type of placement that the youth will go into. Upon entering placement, the PO will also complete a case plan identifying the strengths and needs of a youth, and collaboratively the PO will work with the program throughout in addressing these identified needs and measuring progress. Placement reviews are conducted periodically, and the judge at some point will determine an appropriate time for release when community protection is no longer an issue. An appropriate aftercare program will be identified, and the youth in most cases will be returned home on probation at one of these aftercare programs.
Our child was just taken out of our home and put into a placement, and I'm not sure what our obligation is at this point.
Are we responsible for paying anything?
When youth enter placement, it is important to understand that there are significant costs associated with that placement. The county uses different funding sources to pay for those placement costs, and the parents may be responsible for some of those costs. The first thing that we try to do is to identify if the family is able to access some federal dollars, and if so, that may reduce or remove the parent's responsibility to pay. Once your youth goes into placement, somebody from the county will be contacting you to interview you regarding your financial information. It's important that you cooperate with that person so that they can determine if we can access the federal dollars. In addition to that, you will also probably be required to attend a hearing in the adult section of the family court for a hearing officer, and that person will determine if you have any financial responsibility towards the cost of placement.
The judge just ordered me to pay a whole bunch of different fees. What is restitution and what are with the court fees?
As part of the balanced and restorative justice concept, we incorporate restitution so that the youth can make another victim whole whenever a crime has occurred. Restitution is often ordered based on the youth's ability to pay the restitution as well as the amount of restitution and damage that actually occurred. Also, there are times when fees are ordered by a judge. These fees are used to offset court costs, education programs, and also victim compensation programs.